You are most welcome to come and participate in this particular talk, which I understand will be very exciting and interesting, particularly for practitioners today. My name is Josephine Hadikusumo. I am from CJ Liu & Co. I'm a technology lawyer as well as a mediator and a trained mediation trainer. And a mediation trainer for many years. I'm also a council member at the Borneo International Center for Arbitration and Mediation. Today, we will be talking about maneuvering through multi-party and multi-contract disputes. And even though this talk is framed particularly for our practitioners, if you are a business user or a business owner, you will find something good in this talk as well, something useful, hopefully. And I am delighted to introduce to you our distinguished panel for today. We're very, very lucky to have Kevin, Jun Liang, and Yvonne joining us on this panel. All three of them are very distinguished and established practitioners and dispute resolution experts in every form. So they are litigators, they are arbitrators, they are mediators, adjudicators. They will be able to speak on every aspect of dispute resolution with regards to multi-party and multi-contract disputes. You already have the blurb with their CV on it, their biodata, so I will not waste any of the panel's time today by going through it. However, I will let you know something interesting about each of them, which is not on their CV. Kevin, in particular, is also known as a sports weekend warrior. So unbeknownst to everyone, because of his scholarly appearance, he's actually very active in pickleball and futsal. Basically a devil during the weekend. So this is something interesting about Kevin. I hope he brings his competitive spirit to this panel. And the next person with an interesting hobby is Jun Liang. You can see Jun Liang looking like a gentleman, a smooth, suave gentleman, but actually,
I think that's a good idea.
He is an avid off-roader. So on the weekends, he takes his Ninja Turtle off the beaten track to explore the wonder and beauty of Malaysia. And that's Jun Liang for you.
The counterclaim a long time ago, but they might ask you to pay costs if you wish.
And our third speaker is Yvonne. And Yvonne is something of a table tennis champion who has participated in the Malaysia-Singapore bar bench games in this very sport. So everyone here is very sporty, very competitive, and have very, very interesting lives beyond being dispute resolution experts. So I welcome all three of you. And without further ado, I'm going to pitch you an interesting question. All three of you can answer at your leisure. And the first question to start with is, what are the typical challenges in your experience that arise when dealing with multi-party or multi-contract disputes? And how do these differ from more straightforward or bilateral disputes? Kevin, do you have any input from your experience?
Josephine, thank you. And thank you to BicTok for inviting me to speak today. Yvonne, Jun Liang. There really is no one size that fits all. And many times when we are faced with this particular situation, there are a whole host of things that we have to look into when advising a client or the client, or even if we are sitting, how we deal with the parties. It's very easy for us to wax lyrical about the potential benefits from cost efficiency, legal fees, time saving, potentially forcing consistent outcomes, or rather avoiding inconsistent decisions or outcomes, streamlining discovery, and so on and so forth. But a lot of the times, a lot of this really sits and remains in theory. There are a lot of challenges in how we deal with multi-party contracts, and especially multi-party disputes in multi-party contract context. It starts from very early on in terms of How do we join and consolidate proceedings, especially getting all the parties to agree to a unified proceedings, and coming to agree to a unified set of proceedings. A lot of the times, the challenges can start very early on from jurisdictional issues, competing or different arbitral clauses, for example, or dispute clauses. And how do we bring all these parties together to avoid the obvious pitfalls like jurisdictional challenges, or how to define the parties, or how to simplify the procedure, or how to control competing interests in multi-party disputes, in multi-party contracts, in multi-party arbitration agreements that adopt or use a different set of rules, different parties wanting different arbitrators, arbitrator selection, varying interests, competing interests. So there are a lot of potential challenges that parties must think of or should think of. And one obvious circumstance would be how to get, say, an employer, a main contractor, and a subcontractor, if not multiple subcontractors, to come on board in one dispute, and how to manage all their competing interests in such multiple contracts, especially where there could be different and not necessarily back-to-back provisions flowing from the employee all the way to the subcontractors. So those at least to my mind, some of the obvious challenges that we all have.
So managing competing interests being one of the prevailing challenges. Well, what about Yvonne? Do you agree with this, or do you have anything further to add to this list of typical challenges arising? Yes.
Yes, so I definitely agree with what Kevin has shared, and it's quite a comprehensive commentary that Kevin has shared already. Maybe I'll come from the angle of counsel, right? And from a more from the practical administrative perspective. Now, from my experience, I think in terms of multi-party or multi-contract disputes, right, potentially within the same forum, there's definitely the increased procedural complexity in that, well, in a bilateral dispute, you've got two parties, you've got the tribunal, something as simple, right, as finding dates, hearing dates. In modern day arbitration, it could go out, right, by a year and a half. Kevin's shaking his head. Could be 2 years in Malaysia because everybody's very busy, right? It gets even more complicated when you have more parties within that same dispute resolution forum. Now, coordinating timeline schedules therefore becomes a real issue because you don't want, for example, your arbitrations to be heard only 5 years later. So in order to avoid, right, delaying tactics by some or more of the parties, what I would suggest that, councils can think about is, well, do more of the heavy lifting behind the scenes. For some reasons, when counsel appear in front of the tribunals, you must have a word in. You must look as if you're winning, right? So if we're discussing all these procedural issues in front of the tribunal, it's harder to step away from your initial position. Whereas if you do these behind the scenes, you're talking to each other behind the scenes, getting things agreed before you then present it to the tribunal or narrow it down, right, to just a few things that you can't agree on. That I think might help, right, to deal with some of the practical challenges that would typically be faced in a multi-party, multi-contract dispute.
So managing competing interests and now managing timelines for all the hearings. What about you, Jun Liang? What do you think are some of the typical challenges?
Well, I think Yvonne makes a pertinent point about speaking to each other behind the scenes, trying to iron things out. Because if you have multi-parties, particularly if you have more than 3 parties, then managing it from the perspective of an arbitrator becomes very difficult if everybody wants to have their say. Let's take an example. If you have four parties, and that's not uncommon, because if from an ICC survey, I think about 30% of their cases involve arbitrations of 3 parties or more. So let's say you have 3 parties, 1 claimant and 2 respondents, and a panel of 3 agreed between parties in a common arbitration agreement. Claimant picks the first arbitrator. Which of the respondent is going to pick the second? We assume that respondents are aligned, but they might not be. Now, so if parties don't work that out, let's develop that example. 3 respondents. How are we going to pick the second arbitrator? So 1 party is going to be left out. And if we leave it to the appointing authority, the appointing authority is not going to be in any better position. So some rules contemplate a situation where the appointing authority disregards everybody and makes his appointment. If it's a panel of 3, they appoint all 3 without hearing arguments of parties. And of course, parties are free to conflict them out. But you see how this process can get protracted. So that's the arbitrator. Then quite typically as well, especially in construction disputes, you may have a minor subcontractor who's dragged into a dispute between the employer and the main contractor. Subcontractor may only be involved in, say, the lifts, small part of this dispute, but he has to sit through the entire arbitration. So as the sitting through an entire arbitration will only escalate your costs, and that's assuming you're sitting through that arbitration in your backyard. If it happens in another jurisdiction, then there's all that cost that comes with it. So the arbitrator needs to be mindful about time scheduling. Another practical aspect, choice of law. The seat. If parties don't agree and we have got 2 arbitration agreements, two separate contracts, and it's being arbitrated together, common facts, common issues, common project, there's going to be arguments as to where the seat is. And we know from that argument, there's going to be an argument about who's going to be, or where is the supervising court going to be. So practical issues of that nature, I think, will have to be resolved by parties when the dispute arises, because it's only then typically when one sees how a dispute pans out and what are the issues that will arise. Lawyers drafting the arbitration clause at the outset may not be able to foresee the extent and scope of possible disputes.
So the typical challenges our speakers have talked about are competing parties' interests, logistical issues like timelines and finding the right date, and then also practical issues arising from parties' decisions and choices when it comes to choice of law, seat, and things like that. Well, that's very interesting. But when disputes arise under several related contracts, possibly with different governing laws or dispute resolution clauses like what Junliang has talked about, how should practitioners approach the issue of jurisdiction and forum? Kevin, your thoughts? You're muted.
Sorry. The one thing that I will emphasize and stress, and I'm sure Junliang and Yvonne will agree on this point, lawyers and counsel must be very careful right from the outset in understanding what the arbitration clause is and understanding what the contracts are. It's not just a matter of jumping into the arbitration simply because there's a clause, and then only finding out later on, much later on sometimes, that things have gone so far awry that the entire decision, even if it goes in your favor, might be jeopardized. And there's one case in Malaysia, at least among us Malaysian, and I'm sure the Singaporean lawyers would be familiar with. It's a relatively, well, it's not a new case. It's the case of Thai Lao Lignite and the government of Laos. And the circumstances there, of course, were a little peculiar, and which is what led to a lot of complication. And there, the company, Thai Lao Lignite, was given the concession to mine in Laos. And what happened then was that company set up a subsidiary in Laos, which was then given the license to mine and carried out the actual licensing. The mining work. There were some disputes. The project development agreement or something like that was terminated, and an arbitration was commenced under the PDA against the government of Laos, but naming both parties, which is the Thai Lao Lignite Company, as well as a subsidiary, Hongsa Light or something. And they went all the way throughout, and they completed the arbitration. The reference to arbitration was only under one contract, which was the Project Development Agreement, or the PDA. An award was given in favor of the private company, which then moved to enforcing that particular award all over the world, but ultimately was set aside in the Malaysian courts because the courts there found that the arbitral tribunal, in finding for Hongsa, which was not even a party to the PDA, or even that particular arbitration agreement, had exceeded their jurisdiction. And they ended up setting aside the entire award several years later. And you can only imagine the amount of costs and legal fees that would have been, I can only imagine, would have been spent only for that entire award to be set aside several years later. And the cost would not have only been, would have been limited to that particular case alone. In terms of the arbitration, there would have been court costs in applying to set aside the award. There would have been all those other costs associated with attempting to enforce the award, which I understand went as far as the US, France, the UK, as well as in Singapore, and perhaps even some other countries as well. So I think if there's anything that I would like to emphasize is to be very careful right from the start in terms of understanding what the clause is, what the agreement is, and what are the parameters in the context of the clause, and not to extend it to a point where the entire arbitration itself could ultimately be jeopardized.
You're suggesting this should happen before a dispute should arise.
Very
So do
early
you
on.
agree with that? Do you agree with that, Jun Liang? If not, how else should practitioners approach the issue of jurisdiction and forum?
Well, I think having I'm sure, like Yvonne and Kevin, part of our practice in court, when faced with multi-party disputes, the first thing we look at is whether there are common issues of fact. Is it a common if we're looking at construction projects, is it the same project? Are we looking at the same delays? Are the contracts intertwined in some way? And then we trip over ourselves on those issues and we say, let's consolidate. And we err on the side of consolidation because we are worried about conflicting findings, inconsistent findings. But in the world of arbitration, when we are looking at possibly arbitration agreements with different seats, different choices of law, same issues might well be decided in different ways. The same dispute might well be decided in different ways. And when one consolidates, then the tribunal will have a real difficulty. That's one. And then when the award is out, which court is going to supervise that? So I come back to Kevin's point. When we are faced with this multi-party dispute, we've got to be careful about what the arbitration agreement says. That should be the first port of call, I think, first point of consideration before we even venture into the question of whether there are common facts, common issues, convenience, conflicting findings, and so on. So I would say ideally keep them separate unless you are confident that the arbitration can proceed seamlessly and that the eventual award will not be exposed to setting aside grounds.
So, I mean, that is like a perfect lead into my next question, which I hope Yvonne can respond to, which is, I mean, is it ever appropriate or realistic to consolidate multi-contract claims in one proceeding? And what factors should practitioners weigh in deciding this?
And in terms of consolidation, definitely, right, in certain appropriate circumstances. Now, what I consider some of the common factors to consider would be whether it would be more efficient. So understanding the dispute, right, at the heart of it, what are the issues which parties are not in agreement about? Would the two parties in, let's say, the head contract, the main contract, be in the best place position to unlock that dispute? Now, if there's a specialist subcontractor involved, for example, in a construction dispute, right, and the dispute actually surrounds or arises from a very technical issue or multiple technical issues, and the input of that specialist subcontractor is critical in unlocking the dispute, right? Now, to consolidate the two otherwise separate disputes between the developer, the main contractor, and the main contractor and the subcontractor, that might make sense because, as Julian had mentioned just now, the risk of having inconsistent findings, right, would potentially lead to unfairness between the parties. Now, without the specialist technical knowledge that would have come out of the specialist subcontractor in the second dispute, without that in the main contract dispute, the decision that the dispute resolution neutral might get to in that main contract dispute forum could be very different, right? Therefore, in terms of fairness and efficiency, that's one of the, I think, common factors to have in mind when thinking about whether to consolidate multi-contract claims.
And what do you think, Kevin? What factors should practitioners weigh in deciding whether to consolidate a multi-contract claim?
Okay, the thing is, a lot of the times, by the time a client comes to see Julian or Yvonne, a lot of the challenges would have been baked in already. And for example, a typical scenario, a typical situation where there are multiple contracts which all depend on each other is in a typical construction contract where you have an employer who has a contract with the main contractor, and they pass on a lot of the obligations to separate and several subcontractors. And I think all of this here and it happens all the time, not just once or twice, all the time. You have different or differing or different dispute clauses between the contracts between the employer and the main contractor, and then between the main contractor and the subcontractors. Sometimes you find different dispute contracts between the main contractor and several subcontractors altogether. So I think the professionals who are advising these parties in the early days before they entered into these contracts should look into the contracts and make sure that there is some harmony and consistency between these clauses. Because once there's consistency between these clauses, it makes a lot of our lives a lot easier in trying to bring these potential disputes together, consolidating them, or at least having them heard together, instead of having to see how we can harmonize them, especially when they're differing clauses. That's just something that I would suggest from very early on.
Well, it does sound, you mentioned harmonization, and Yvonne also talked about coordinating these things between parties. It sounds like you do need a lot of coordination. So what are some of the strategies for managing communication and coordination between multiple parties who may have divergent or even conflicting interests? Julian, thoughts?
All right. I think, unfortunately, when one looks at consolidation, most institutional rules provide for that. And it really depends on whether that consolidation happens before the appointment of the tribunal or after. If it's before, it goes to the appointing authority, for example, the director of the AIAC to decide whether it should be consolidated. If it's after, it goes to the tribunal. But I think in either of those situations, it requires parties to think through the practical aspects of the entire dispute resolution process, what evidence they are able to bring to the fore, and address whether it's the appointing authority or the tribunal upfront, so that the party making the decision on the consolidation is mindful of all practical aspects, aside from looking at the legal aspects, the issues, the disputes. For example, one relevant factor I think would be the availability or the ability to call expert evidence. Now, between Kevin's client and Yvonne's clients, two big boys in dispute, they dragged my client in because of an arbitration agreement to to which I'm a party, but we can't afford an expert. So what is my client going to do in a dispute where I've got something, my client has got something at stake, but I'm in no position to match the evidence of either of those other parties in that dispute resolution process? That's one. And secondly, in the example that I've given, if my role is very limited, my involvement in the dispute is very limited, do I need to sit through the entire dispute? Because in a bilateral dispute, for example, between my client and Kevin's client, much of that evidence will not come out. And I won't have to deal with it. Otherwise, in a multi-party dispute, I've got to sit through all of that because I'm taken to have notice of all the evidence that comes in, and I've got to deal with all of that. That's one aspect. From the perspective of counsel or party representative, it is perhaps a little bit more selfish. What would be one of the factors that we will look at is perhaps, for example, if I'm the main contractor and I'm in the dispute with the employer, I may not necessarily want my subcontractor to come on board because I don't want him to say the things that I know he will say. In a multi-party dispute, I can't control that. So strategically, I might want to keep the disputes separate, right? And I think it applies to all parties. Yeah. So
that's your strategy. What about Yvonne? Have you got strategies to share with this group on how you can manage coordination between parties who have conflicting interests?
Well, I've also objected to consolidation before, right, for strategic purposes. Now, that aside, I think in terms of managing coordination in multi-party disputes, an early case management approach would be very helpful. Now, I remember the days in the past when, I don't know whether the practice in Malaysia is slightly different, right? But there might be some tribunals who would say, okay, I'll give you the first few steps, right? Or the next few steps, which we're going to do. But I'll not look through to the end because I don't know enough about the dispute yet. And therefore, we'll play by ear as it comes. We'll come back for another procedural meeting. And then we can decide what else needs to be done. Now, I can see a lot of sense in that, but at the same time, it might become very protracted. So I would say bite the bullet right at the start, especially if you've got multi-parties, as long as you understand what each party's role is, right, in the dispute. Okay, it's going back to, let's say, a construction dispute again, you've got the developer in there, you've got the main contractor in there, you've got the consultant in there, you've got the subcontractor, for example, right, in there, and you know what each party's kind of preliminary position is because of the initial papers that have already been put in when the arbitration is being commenced, then just bite the bullet, do early case management, set it out, the entire process as much as you can, because there is still room later on for changing things up if you require to. But once you've got things set in stone, people are looking at something, they're working towards something, and hopefully, right, even those hearing dates are set, right? If it has got to be a year and a half out, it's a year and a half out. But in the time in between, parties know, okay, we're all working towards a goal, right? And that is whatever we do within this year and a half. If we need additional steps, we'll apply for it, right? But within this year and a half, we're going to get to this hearing, we're going to get this matter heard, we're going to get a decision from the tribunal. So in terms of a situation, especially when there are lots of people wanting their say, right, on the procedure, I would suggest just biting the bullet at the start and setting something down, right, to the best that the tribunal can, might be a good way of ensuring that people stay on track.
That sounds like a great strategy, but it sounds like in both of your strategies, a lot depends on the parties, knowing the parties, understanding their interests and where they're coming from, and then picking the right path to minimize issues with divergent or conflicting interests. So, Kevin, my next question would be, how do power dynamics among parties affect the dispute resolution process, in your opinion? And how can mediators or counsel or basically help rebalance the playing field?
Typically, following from what Junliang had said, very typically what happens in a multi-party dispute is the smaller parties. When I say smaller, I mean the parties that are probably not as well financed, or perhaps maybe even has a smaller claim, or has a smaller stake in the arbitration. A lot of their case tends to be submerged into the larger issues. They tend to be. I'm not saying that it necessarily will be, but they tend to be, subsumed in the larger picture, and they're taken as one and the same with another party's issues, and the deciding party, the neutral party, the arbitrator or the judge, tends to gloss over a lot of their particular complaints. And I think it's very important for an arbitrator or a judge or the adjudicator here to pay very specific attention to all the parties, all their issues, and to give each party equal time and ability and opportunity to present each and every one of those cases. I'm not saying that it tends to happen, but it is a very natural thing for the smaller claims to get, in a way, left out. And really, this is where the role of the arbitrator or the strength of the arbitrator or the neutral third party who comes in and who needs and must ensure that all parties are given an equal amount of time to ventilate their cases. This is how, at least, I think we can cut through or at least neutralize a lot of the power play and power dynamics in a dispute.
Okay. Well, Junliang, what do you think?
Yes, I think the reality is that the tribunal will focus on the big ticket items because of time constraints, cost constraints, and as Kevin mentioned, invariably the party involved in the smaller claims might get sidelined. So I think the only way balance can be achieved is if the tribunal is cognizant of this and gives each party the equal right to be heard.
That sounds good. But now we come to the part of the talk I think is my favorite topic, which is mediation. Now, I'd like to ask Yvonne this question because Yvonne is a mediator herself. And I just wanted to ask, in your experience, how effective is mediation in resolving complex multi-party disputes? And what unique advantages or disadvantages does it bring to the table in this context?
I'm a fan of mediation as well, I must say, Josephine. And in
Yes.
fact, in a recent case that we did, we mediated with multiple parties. There were 5 of us, 5 different parties with their counsels. It was a large room. And what was spectacular, it settled in the end. What was spectacular was the flexibility that can be exercised in mediation, in that the mediator very quickly at the mediation realized that, well, I need to get this group, party A and B, right, talking about what would otherwise be a deal breaker. While they are negotiating that and talking to themselves in a separate room, right? Now, these 3 other parties, in terms of apportionment of a liability, they need to be talking to each other as well, right? So there were actually parallel discussions being had, right, by different parties. The mediator basically saw that as a way of saving time because we wanted to finish in a day, right, and also draft the settlement agreement if possible, and all go home not at 12 midnight, but a sensible time. So, he had that good sense, right, to exercise flexibility in the mediation, split up the parties, identify deal breakers, and then get discussions ongoing in parallel. So I think in mediation, it's very dynamic, and that was well played out. We all went home very happy at 8 p.m., so that was good.
So would you say that the flexibility a mediator has in the problem-solving approach that he or she takes is an advantage of mediation?
Indeed. And I think a mediator who understands how to unlock a dispute, right? There could be different critical issues that just need to be unlocked between different parties. A good mediator would be able to identify that and then just zoom in on that. Because once you unlock that, the rest are actually very commercial. You can talk about it, put everybody in the same room, and you can say, well, all shake hands. These are non-issues, aren't they? Right. But the skill of identifying what would unlock the dispute, I think that would be very good to have, very valuable in a good mediator.
So as a trainer, we always say there are three things that we look for in a good mediator. One is your ability to have a process that's sensible, that makes sense. Two is your ability to problem solve, and sometimes doing it on the fly and being creative with it. And three, very important, people management. Being able to manage the personalities and emotions around the table gives you that added advantage. Do you agree with that, Junliang? Do you have a mediation story that you can tell with regards to the a multi-party dispute, perhaps?
Yes, not as a mediator. I'll tell you why in a moment. But certainly as a party representative, I have seen how effective it can be, and I would say that a mediation is as effective as the mediator can be. So even mediations in courts, when the mediator is not shackled by due process paranoia,
Due process paranoia. Okay, I like that.
he or she can push the right buttons, ask the right questions, and get the answers out without being fearful that of any final decision being set aside for a breach of natural justice. When the right questions are asked and the right questions are pursued and the answers elicited, I think it goes a long way towards putting parties in a realistic setting. And I've seen how that work. Not a large dispute. I think it was sometime last year. Very counsel who got along very well with each other. A few of us. We tried very hard. We all felt that the matter should be settled, but we failed. Not because of legalities, but simply because of ego. Nobody wanted to back down very much. But the judge tried. This was one of our construction court judges. She tried, and she realized then at some point that maybe something somebody needs to be on the stand to be questioned on this for a reality check. She sent us back out. All this was with the consent of parties for her to mediate. So she sent us back out for the trial to go on for a short while more. And she interrupted that particular witness who was an expert and said, "Look, I want to hear the other expert on this point." And what we realized thereafter was that she wasn't. It was not her who wanted to hear the evidence. She wanted the parties to hear the evidence of both experts. Then after the experts had given the evidence on that one point, she called parties back in the room and said, "Look, consider your position." So between lawyers, we said, "Okay, let's speak to our clients." Had no luck. We went back to her and said, "Look, Judge, I think we really need to get on with it. We can't resolve this." And she brought parties back in one at a time and both together. And to our surprise, by the end of that day, the matter was settled. The dispute wasn't large, but the gap was big.
The gap was big.
The gap was big, and she resolved it. So I've seen examples like that where the right procedure, I guess, not being a trained mediator, I would say the right procedure, the right processes, and recognizing where parties stand, that made a huge difference to the mediation process. And whilst I don't practice as a mediator, I am a believer.
That's an excellent mediation story. What about you, Kevin? Have you got one to share with this group about the advantages of mediation, perhaps in a dispute?
I absolutely agree with both Julian and Yvonne. It's just perhaps very, very helpful for parties to come together and resolve the dispute, especially for, at least to my experience, the larger disputes. And a lot of it has really to do with not even as much, like as Julian had mentioned, not even as much the training, but the personality and the strategies that the mediator employs. And I think I've shared this with you that very recently, and I've been involved in several mediations, both successful and not successful. But disclosure.
Did you say not successful? Not successful?
Both successful and not successful.
Oh, okay.
Right.
Okay.
And point of disclosure, all of these mediations that I've been involved in are all court convened mediations. I've not been involved in any private mediation. And I've always found, at least for those where the mediations have been successful, it always came down to the mediator. And I found that the personality of the mediator has always helped. Of course, employing strategies, for example, like what Julian had explained, and how skillful that particular judge was, and what she did. I think a lot of it comes down to the personality of the mediator. And the moment the mediator gains the trust of the parties, even though what may have seemed quite impossible, however hard lawyers may have tried to bring the parties to the table, sometimes when the mediator, the personality of the mediator gains the trust of the parties, I found that it's very, very helpful to bridge a lot of the gaps with the parties. So yes, I too am certainly in pro mediation, and I'm going to suggest there's one other thing, which is I think at least in the Malaysian context, I can't speak for the Singaporean context because frameworks are there already, but at least in the Malaysian context, I think we should all start to consider compulsory mediation, at least for certain types of disputes, before as a condition precedent prior to the parties being even allowed to file an action for the particular dispute.
I'm totally in support of that. I'm totally in support of that particular view. But I know that those who are listening in, our audience, some of them may be mediators, some of them may be practitioners or mediation advocates. So from that perspective, what should a mediation advocate be doing differently in a multi-party setting compared to a traditional two-party mediation? For those who are mediation advocates, counsel. Julia?
From the perspective of, sorry, I didn't catch the last part of your question, Josephine. Was it from the perspective
of a mediation advocate, a counsel supporting parties through a mediation? How should they be doing things differently in a multi-party setting versus a traditional two-party mediation setting?
I think in the main, it's recognizing that there are other interests in play. There are other parties and other interests in play, and whatever terms put forward must be palatable to all parties. Otherwise, you're just not being realistic, because all it takes is for one party to disagree, and the entire process will fail. That's my little experience.
What about Yvonne? Any tips on what a mediation advocate can effectively do in a multi-party setting?
I like to look for aligning interests as well, creating alliances. So there was a case where we're acting for a subcontractor. It forms the issues which my client were involved in actually only formed a small part of the entire dispute. But as parties were speaking in the main room, right, the main contractor and the developer was there on that occasion. And I realized, the developer's not saying something. And that's actually great for the main contractor. And then as we stepped out, I pulled counsel aside and said, did you realize that he wasn't saying that? So, do you want to try this angle? And when he was successful, right, on that point, we basically tagged along. So I think in terms of where interests are aligned, right, of course, with clients' blessing as well, there's no harm supporting each other, right, and creating these alliances, which will be for the ultimate benefit of your client as well.
Now, that takes skill and experience and a certain kind of wisdom and intuition, I feel, to be able to suss out when to say what to whom and when to detect where alliances may potentially reside. Yeah. So I wanted to say we have about 15 minutes to go. I wanted to just take a break and ask the audience if you have any questions whatsoever for this distinguished panel or for me. Please be sure to put it in the chat box, and we will try to get everyone's perspective on your questions. So if you have any, just key them into the chat box. You should see it at the top of your window. So while waiting for these questions, let me ask the next one. And this one has to do with practical tips and case management. Are there any procedural or case management techniques, whether in arbitration, litigation, or mediation, that you have found particularly useful in keeping complex disputes on track? Kevin, any tips to share?
Well, as an arbitrator, then I think there has to be a very clear communication protocol, and all the parties to comply with that particular communication protocol, which which should be set up as early as the first preliminary meeting itself. The rules must be set out there. Who is the lead person in each team, who communicates, to ensure that communication is with all parties and not just with the arbitrator alone. And ensuring that the parties stick to those rules right from the start, because I think we've all seen when the parties do not follow these, well, at least the communication protocols, things can go awry very quickly. And we've seen unnecessary allegations, points being made against one party or the other, including the arbitrators. So that is certainly something that I would suggest.
Oh, okay. And what about Jun Liang? Any tips, case management or procedural techniques?
Yeah, I think doing the heavy lifting up front, as Yvonne mentioned just now, there's a lot to be said about it. Certainly coming from our court system, the heavy lifting is done on the eve of trial, right? Then that's when we discover how strong our case is. Doing it up front, even when dealing with experts, you've got your CR protocol on dealing with expert evidence, where the tribunal takes an active approach, right? Very early on, experts will have to agree or disagree on their approaches, on the theories, and they then go away and write a draft report on what they disagree on. So you won't then end up on the eve of the hearing with two reports coming from very divergent angles. So that's one aspect which is useful. I've also come across a couple of other principles. The Kaplan opening, named after Neil Kaplan, where parties effectively are asked early on, before the hearing starts, to essentially put their case forward at a hearing, a pre-hearing hearing, if you like. And that's when parties are forced, or rather party representatives are forced into a reality check. What can you sustain? What can't you sustain?
Mm-hmm.
That also involves or requires the tribunal to be on top of the file and ask probing questions, so that parties can then go away and rethink what evidence they are going to call, which part of their case are they going to drop. And I think experience will tell us that by the time the hearing actually starts, and even by the time the witness statements go in, it will be more focused. There is also that Reed retreat, I think named after Lucy Reed.
Wow.
Where panel members, if you're looking at a tribunal with multiple panel members, they discuss. It's basically a caucus of involving the tribunal. They sit together and they need to be on top of the dispute and the evidence, and they discuss amongst themselves what is the direction the arbitration should take, what sort of evidence should be focused upon. and they then issue directions. So those are examples of I think methods that can be used. But what I personally find the most useful from a very elementary standpoint is to start with a clean sheet. Start every arbitration with a clean sheet. Now, I've said this in a different discussion. What I used to do when I first started sitting as an arbitrator was to circulate draft procedural directions ahead of the first procedural meeting. Number one, to be more focused. Number two, to show that I've been doing my work, right? But what I then realized very quickly is that parties will just come back and tick off those directions, agree or disagree. Nobody applies their mind as to whether pleadings are necessary, oral hearing is necessary, whether experts are necessary, or whether it can only be whether it needs to be only a document-only arbitration. What I do these days is to ask parties to think about these things, and we have our first preliminary meeting. And then I find that without boilerplate directions, arbitration will be more efficient.
I see. So we have these useful tips from the perspective of litigation and arbitration. What about in mediation, Yvonne? Are there any techniques in mediation that you found personally particularly useful in keeping complex disputes on track? We're talking 6 people in the room, 6 different parties perhaps in the room. How do you keep things on track without it descending into chaos?
Interesting question from a mediation perspective. I haven't thought about it from the mediation perspective, I must say. But if I would point to one thing, I would probably say that putting in good mediation case summaries would be helpful. If you've got multi-parties, many different issues, you will want as counsels, right, and as mediator to see that counsels have put thought into what needs to be surfaced and discussed at the mediation. If there are overlapping issues, great, you can group them together, think about a strategy. And I think the efforts that counsels put into writing good mediation statements cannot be undermined. It will help to drive the mediation, right, to become more efficient eventually.
I totally agree with that. And I think for me personally, what has helped would be frequent use of private sessions and breakout rooms. By breaking up the parties into private sessions, you are better able to elicit the interests of the parties without the noise being in that. And I think that also helps. I liked your tips very much, all 3 of you. I wanted to touch a little bit before we end on confidentiality obligations. How do confidentiality obligations play out in a multi-party scenario, especially when parties might want to caucus separately, like I mentioned, or have asymmetrical information? Kevin?
Confidentiality will always be a challenge in multi-party disputes, especially when one party, where 2 parties might know of something because of the nature of their contract, and the third party need not know or have that information. It's very easy for us to suggest, and in theory, that the party should draft very comprehensive confidentiality clauses right from the start. But it's certainly not practical at all, because what happens more often than not is a lot of the times confidentiality clauses are boilerplate clauses, and we'll not be able to foresee a potential multi-party dispute, which might happen some 2-3 years down the line after a contract is signed. At least to my mind, I think the best and the safest thing to do in such a situation where disputes are consolidated or to be heard together is for the parties then to agree to enter into separate confidentiality agreements in the context of that particular dispute, and to preserve secrecy and confidentiality at that point of time. Of course, you can come up with need to know protocols, but all of that can be embedded in that particular confidentiality agreement to bind the parties in that particular dispute, and only in the context of those agreements. That at least is something that I would suggest.
I would say, to add to your point, in the mediation context, there is a blanket confidentiality expectation that all parties, no matter how many involved in the mediation, would have to agree to. And the entire process is also without prejudice. So I get what you're saying. I want to be mindful of time, and looks like we don't have questions from the audience. So I will ask the last one. And this one is really just your 2 cents, all of you. With increasingly complex commercial arrangements like joint ventures, consortiums, and project finance deals, do you see dispute resolution mechanisms evolving in a way that would better address multi-contract, multi-party disputes? Just your quick thoughts on that. Junya?
I think the answer is not so much in dispute resolution, I suppose. I think the better answer would be in dispute avoidance, and that would be at the contracting stage. So that lays the platform for Yvonne to tell us about her experiences in Singapore, because they've got standard form contracts that deal with that.
Yes, Yvonne?
Well, thank you, Jun Liang. Indeed, very excited to tell you about this Singapore Infrastructure Dispute Management Protocol, which we call SIDP. It was introduced sometime in 2018, and particularly targeted as Jun Liang has said, dispute avoidance or management of complex disputes. Now, what it offers is, instead of a traditional multi-tiered approach, right, which we see in dispute resolution, right, and captured in our contract, the SIDP allows a multi-prong approach, which is to say, right, over the course of a project, there might be many different issues that arise. Certain issues might be easily resolved by way of a mediation. Certain other disputes might be technical in nature and would require an expert opinion, right, or determination even. Now, certain other disputes are so entrenched that parties would not be able to mediate or unravel the dispute by way of getting an independent opinion. So it has to go to arbitration. Now, a platform like the SIDP then offers, right, by way of introducing a dispute board, 1 person, 2 persons, or 3, who would be able then to advise the parties, actually, let's split up your dispute. Let's make it less complex. Let's downsize it, right? And we can apply a different ADR to each part of the dispute. So that's what we're doing in Singapore at the moment. We're trialing it, right? And it's worked quite successfully in a couple of our projects. So happy to share about it at any other point of time. Yeah.
Well, this is exciting. Well, thank you, Jun Liang and Yvonne. Kevin, any last thoughts before we end the session?
I agree with and certainly echo Yvonne and Jun Liang, and I think we need to import a lot of these techniques and thinking actually,
yes,
into our Malaysian context. Singapore is pushing collaborative contracting, and a lot of it is because I think when I say this respectfully, the Singaporeans see and understand that the point of a project is to get it done and not to get the parties stuck and mired in disputes. And I think we need to adopt that thinking and that approach quickly. And projects in Malaysia are getting larger and larger and more complex. And I think it is timely that we start thinking this way.
There is nothing wrong with imitation. It's the sincerest form of flattery. And if Singapore is doing something good, I'm all for Malaysia exploring the same potential. And with that, I wanted to thank the audience as well as my distinguished panel for your time today. I'm sure you have given lots of gems and tips and techniques on how to manage complex multi-party disputes. Now, to our audience, thank you for spending your evening with us. If you have any questions, please be sure to channel them through our BicTok administrators, Marshall and Marie. And we look forward to seeing you at the next BicTok. Thank you, everyone, and have a wonderful evening.
Thank you.
Thanks, everyone.
Thank
Thank
you.
you.
Good day.
Thanks, Josephine,
Bye.
Yvonne, Kevin.
Thanks, Josephine. Thanks, Yvonne.